Welcome aboard, applicants. We are going to do question 1 from October 2019, Baby Bar, California. Okay, we're beginning with the call of the question. With what crimes, if any, may Daniels be charged? What defenses, if any, could she raise? And what is the likely result? Discuss right off the bat. We should instantly be zooming in on the word crimes. Absolutely, which means we are in criminal law land. Which means when we deal with criminal law, we have our checklist, our shopping list that we insert so that when we read the question, the facts, we are being zoomed in on those particular important issues so we do not miss spotting issues. Okay. We're taught here. Okay, so murder, structure, theft, crimes against the person, solicitation, conspiracy, attempt, and defenses. This is just my shopping list or checklist. If you have one, please feel free to use it. Supply it at this moment in your essay process, and you should be well on your way to a fantastic paper. Okay, now, going through our question now, starting from the top. Julie Smith hired Deborah Daniels to take care of her grandmother, Nan. Smith informed Daniels that during her daily visits to Nan, she was to prepare Nan's prescription medications by placing the correct number of pills in a dispenser. With the pills placed in the dispenser, Nan could take the correct dosage of evening medications after Daniels left for the day. Smith told Daniels that this task was very important because Nan had previously gotten confused, taken the wrong number of pills, and almost died. After several months, Nan told Daniels that she enjoyed her company and she was relieved that everything was working out because she feared that if it didn't, her granddaughter would place her in a nursing home. Neither Smith nor Nan knew that Daniels was a drug addict who regularly needed money to buy drugs. One day, Daniels went to work at Nan's after ingesting a large quantity of narcotics. Nan did not notice that Daniels was under the influence of drugs, and during the day, Daniels secretly removed jewelry from the home and sold it for drugs. On another day, Daniels told Nan that she had to quit and find another job because she had to make money quickly to pay past due bills for a previous life-saving medical treatment. Unaware that the story was not true, Nan gave Daniels $1,000. Daniels used the $1,000 and went on a 3-day drug binge. During these 3 days, she did not go to work, nor did she inform Nan or Smith that she would not be at work. When Daniels failed to go to work and place the correct dosage of Nan's medications into the dispenser, Nan took too many pills, overdosed on her medication, and died. We should be looking out into our shopping list this next read. Coming up here, Julia Smith hired Deborah Daniels to take care of her grandmother, Nan. At this point, any particular issue spotted? I don't see any. This is what we call foundational facts. Smith informed Daniels that during her daily visits to Nan, she was to prepare Nan's prescription medications by placing the correct number of pills in a dispenser. Still, foundational facts. With the pills placed in the dispenser, Nan could take the correct dosage of evening medications after Daniels left for the day. Still, foundation. Smith told Daniels that this task was very important because Nan had previously gotten confused, taken the wrong number of pills, and almost died. Still, this whole paragraph at this point is foundational facts. Remember, there's no such thing as a homeless fact. With all of these facts, we'll find a particular home within an issue. So, absolutely be confident. We will find where these foundational facts go. After several months, Nan told Daniels that she enjoyed her company and was relieved that everything was working out because she feared that if it didn't, her granddaughter would place her in a nursing home. Still, More foundational facts. Everything's okay because we're going to find a place for all of these facts. Neither Smith nor Nan knew that Daniels was a drug addict who regularly needed money to buy drugs. One day, Daniels went to work at Nan's after ingesting a large quantity of narcotics. Nan did not notice that Daniels was under the influence of drugs during the day. Daniels secretly moved jewelry from the home and sold it for drugs. Secretly removed jewelry from the home and sold it for drugs. Absolutely correct. We have a larceny at this point. Remember, before this, we're looking at ingesting of a large quantity of narcotics, and we're even told by the bar examiners that under the influence of the drugs. So we get double reinforcement that we're dealing with voluntary intoxication as a defense. So let's come down here real quick, take a note of this. Under our theft crimes, we have larceny. We want to make sure to bring out jewelry. But we have a defense. We do have a defense at this point. We want to make sure to couple crimes with defenses as they appear in the fact pattern. After larceny, we want to make sure to talk about the defense of what? Absolutely correct. Voluntary intoxication. Okay. Now coming back up. On another day, Daniels told Nan that she had to quit and find another job because she had to make money quickly and to pay past due bills for a previous life-saving medical treatment. Unaware that the story was not true, Nan gave Daniels $1,000. Coupled with the information above this, what do you think this particular statement, unaware that the story was not true, Nan gave Daniels $1,000, raises? Absolutely correct. This would raise the crime of false pretenses. And this would be of the $1,000. Okay. Daniels used the $1,000 and went on a 3-day drug binge. During these 3 days, she did not go to work, nor did she inform Nan or Smith that she would not be at work. When Daniels failed to go to work and place the correct dosage of Nan's medications into the dispenser, Nan took too many pills, overdosed on her medication, and died. Now down here we have, okay, what is this here? I should say this. Overdosed on her medication and died. Obviously, clearly we have a murder homicide. Homicide of Nan. Now, do we have any structure crimes here? In other words, do we have a burglary and arson situation going on here? I don't see that, because Julie Smith had been given permission by Deborah Daniels. Deborah Daniels had been given permission by Julie Smith and her grandmother Nan to come in and take care of Nan for Julie Smith. Now, so therefore, I don't think we have a structure crime here. So we can delete that. We'd already addressed the majority of our theft crimes. We dealt with our murder crime, which is the homicide of Nan. Do we have any crimes against the person, like assault, battery, false imprisonment, kidnapping, those kinds of things? No, doesn't look like it. Do we have any solicitation, conspiracy? In other words, were there more than one particular criminal defendant working together? No, doesn't look like that at all. Now, do we have an attempt? Now, we're looking at here. Was there an attempted crime here? Well, let's take a look. Well, at the present moment, I don't see one, but we upon further analysis we'll keep that there. Okay, we've already dealt with our defenses, and those defenses will be brought up, like Voluntary intoxication was the one that we were easily able to spot, but there are defenses that might pop up again for homicide of Nan. Now remember, the other one that we want to make sure, because not to forget that we have two separate situations involving an involuntary intoxication situation. Because why is that such a big deal? Well, right here we have, excuse me, right here. After several months, no, excuse me, thank you for your patience. One day, there it is. That's what I wanted to point out. I'm going to put a red on that, okay? Because one day, this is the one day that deals with this particular defense of voluntary intoxication. Now we come down here, this 3-day drug binge, which I'm going to point out here in highlight that with red. This is the separate involuntary intoxication defense situation that we're going to put underneath the homicide of Nan, because it was during that 3-day drug binge that unfortunately Nan overdosed on her medication and died. Now down here, voluntary intoxication. Now remember here though, we may not call it voluntary intoxication as a defense. Some outlines might call that an excuse. You could call it an excuse. We'll probably call it an excuse under this situation here, where the same, now remember, same defense, but it's called it's called a defense for the larceny of the jewelry. Now false pretenses, okay, doesn't let's see, come up here. The false pretenses doesn't necessarily have a defense, because I'm looking up here to quickly go through the facts one more time to see if there was any particular defense that went with false pretenses. I don't see that. So we might be able to, yep, probably just going to leave that as is. Right, as of the present moment, I'm going to delete my attempt. I don't see that here. Okay, so here are the 5 issues that I see particularly in the facts. Okay, excellent. So I'm just refreshing my memory as we go down now. Okay, now under homicide, we want to make sure to lay out our elements. We'll come back and fill those in as the facts, as we get supporting facts. Homicide, actual cause, proximate cause, murder, malice aforethought. We want to make sure to talk about degrees. We want to make sure to talk about voluntary manslaughter. If that's present. And involuntary manslaughter. Okay. Excellent. Okay. Now under, okay, that our defense here would probably be right after, copy and paste here. It'd probably be here. There we go. Paste that in. Okay, right there. Now voluntary manslaughter, we may have a mitigating circumstance, but I don't see that. So we'll hold off on that. They'll be to make a final determination. Then criminal gross negligence. Okay, now under larceny, we're just going to go through and talk about each element in a paragraph technique, our paragraph approach. Then coming down here under voluntary intoxication, we were going to borrow the rule statement that we have up here under excuse, come down here and then apply it to the unique situation involving the taking of the jewelry, and then the false pretenses with the $1,000 that happens. We want to make sure, reminded myself here, conclusion, to be able to wrap up in a summary fashion the crimes and defenses, so our readers, our bar reader knows exactly what we have addressed, in terms of the crimes, and exactly what we addressed in terms of defenses. Okay, now with that being said, let's jump right into this. Homicide. Homicide is the killing of a human being by another human being. Here, Nan, let's come up here. What was it that happened? Nan overdosed on her medication and died as a result of, make sure to come up here, Daniels failing to go to work and place the correct dosage of Nan's medications into the dispenser. Okay. Thus, homicide of Nan. Now, down here under actual cause, we could say, but for Daniels not placing the correct dosage of Nan's medications into the dispenser for Nan to take, Nan would not have overdosed on her medication and died. Thus, actual cause, proximate cause. Here, you can say the state will argue. Oh, by the way, that reminds me as well, we want to come up here and make sure that we want to address the call, crimes and defenses of Daniels. Question mark. State v. Daniels. Excellent. Very well done. Okay, now down here, approximate cause. Here, the state may argue, first of all, foreseeability, that it is foreseeable that if Daniels did not place the proper amount of Nan's, go up here and grab some facts a little bit up here. This, I believe it was the prescription medications. See, all these facts are finding a home, so this is the best part about this. Okay, because those foundational facts will indeed find their place. That if Daniels did not place the proper amount of Nan's prescription medication, Nan may overdose. Nan may overdose and possibly die because, well, now, do we know about the potential of her overdosing due to taking not the correct amount of number of pills? Absolutely. Up here we see this because Smith had told Daniels what? That it was important. Because, right here, because Smith had told Daniels that Nan had what? Up here, grab this again. Should we come up here? That Nan had previously forgotten or gotten confused and taken the wrong number of pills and almost died. gotten confused, taken the wrong amount of pills, and almost died. And now we're going to talk about whether or not there were any intervening events that would supersede, break Deborah Daniels' chain of causation, connecting her to the death of Nan. That is, yeah, exactly. Here, there are no well, okay, I say this here, except for Daniels' 3-day drug binge. Let's make sure I got that spelled correctly. Okay, E. Okay. There are no intervening events that would break the chain of Daniels' causation. Thus, proximate cause. Now, down here under murder malice, we want to start out with a definition of murder. Murder is the unjustified killing of another by another with malice aforethought. That's exactly where malice aforethought comes in. Malice aforethought is what? Or I could say I'm going to say it this way. The mental states for malice aforethought include intent to kill, murder, felony murder rule, intent to cause serious bodily harm murder, and depraved heart murder. Now, at this point, we need to ask ourselves here, Daniels did not intend. Here are the facts. Okay, I'm so glad you're typing out. Thank you. Oh, you're very welcome. Here the facts indicate that Daniels did not intend to kill Nan. Okay, and let's see here. There it is. Now, also, the facts do not support a we'll see here. The facts do not support finding, or do not support, yeah, finding for intent to cause serious bodily harm murder. However, oh, yeah, exactly. It was very hard to pull apart, put back together. That's exactly what this is, and that's why it takes a little bit of time at these, you might say, trickier spots, and that's where we're at right now. Right here, oh, right here, let's do that, and then right here, make sure we're doing our paragraph breaking out here. Well, the thing about the felony murder rule that I'm looking at is, was it a felony? Okay, obviously, the her having possession of drugs would be considered a felony could be considered a felony, I should say. But is that what caused the death to Nan? And that's what we're looking at here. Was Nan's death a foreseeable homicide during the commission of an independent and inherently dangerous felony? And see, I just don't see that. Yeah, this would be considered a very good point. This would be considered a racehorse. Absolutely. Now, at this point, trying to say here that okay, the facts. Here, the facts do not support a felony murder charge for Daniels because Nan did not die as a result of the commission of an inherently dangerous and independent Yeah, that's exactly right. Having a good outline to write from, it essential. But now we're here at the depraved heart murder. Now, here, depraved heart. The state may argue that Daniels is chargeable with a depraved heart murder of Nan because why? Daniels not properly supplying Nan with correct dosage, not notifying, reckless, exactly. Because Daniel recklessly disregarded, excellent job, the life of Nan through what? Not properly supplying Nan with the correct dosage and not notifying Smith that Daniels was not going to show up, and the fact that Daniels went on a 3-day drug binge. Thus, the state may charge Daniels with depraved heart murder of Nan. Now, down here under degrees, first degree. Yep. Oh, right. Yes. No. Is that notifying? Oh, yeah. Yeah, that's exactly right. First degree murder, intent to kill. Oh, first degree murder may be evidenced by premeditation and deliberation and the commission of an inherently dangerous felony. Now, here, the state, well, I don't think that's, here I was going to say the facts do not indicate that Daniels either intended to kill Nan or that Daniels is chargeable with felony murder rule. Thus no first degree murder charge. Okay, down here to second degree murder. All malice not first degree, okay, is second degree murder. Here the state may argue that Daniels is chargeable with second degree murder through the depraved heart murder, reckless indifference to the value of Nan's life. Thus, second degree murder through depraved heart murder. Now we're into the excuses. Because we've already worked through like formal justification offenses like self-defense, defense of others, defense of property, crime prevention, and the like, are a necessity. But we're looking now under excuses. We're looking under the intoxication excuses, or excuse, the incapacity excuse, possibly the insanity excuse if the facts are supported. But because we're only the facts only support intoxication and voluntary intoxication at that's what we're going to zoom in on. Voluntary intoxication is the voluntary, yes, mitigation. That's exactly right. If we had any mitigating factors, like we're going to be talking about that, like voluntary manslaughter, we're going to be addressing that. But right now we're just dealing with the excuse of voluntary intoxication. The voluntary intoxication is the voluntary consumption of an intoxicating substance. Voluntary intoxication may be a viable defense to specific intent crimes. Here, the state, or does it say this, that here Daniels may argue that she was intoxicated as a result of the 3-day drug binge and was not able to have the necessary mental state. However, the state may argue, may counter, isn't that excuse for mitigation? Well, see, that's what I'm saying. I think we're just dealing with the argument of just excuse. They're trying to do is excuse the crime in some way through either like intoxication, voluntary or involuntary. We have a voluntary intoxication here. We will bring up the mitigating factors under voluntary manslaughter. Like some mitigating factors might be heat of passion offense and possibly imperfect self-defense if it's there. Now, however, the state may argue that Daniels was not as intoxicated as she claims because the facts state that what? Let's come back up here and grab some facts up here. That, let's see here. Now here we'll take a look. She did not go to work, nor did she inform Nan or Smith that she would not be at work. When Daniels failed to go to work and place the correct. Okay, nothing in here really indicates the amount of intoxication. But let me come down here because in involuntary intoxication, a person has to be really intoxicated to be classified as voluntarily intoxicated. So the state may argue that Daniels was not as intoxicated as she claims. Well, that's the thing is they are why because however, Daniels will argue or will argue in rebuttal that she was that her intoxication her voluntary intoxication was a result of a 3-day drug binge that she argued about that she was sufficiently intoxicated during the 3-day drug binge. But I think that's just reiterating the facts. So I'm just going to delete that. I don't want to repeat myself in circle. So what we're going to do is here. Therefore, the court will likely find that Daniels was sufficiently intoxicated, or it is likely that I would likely find that Daniels was not sufficiently intoxicated. I'm not quite sure how to put this exactly, but see, therefore the court will likely find that Daniels may have been sufficiently intoxicated. For the excuse of voluntary intoxication. Now, under voluntary voluntary manslaughter, we're going to be looking under heat of passion. Oh, because yes, very good. I should put it because it is uncertain whether the 3-day drug binge would create whether for excuse of voluntary intoxication because it is uncertain whether Daniels' 3-day drug binge resulted in her being sufficiently intoxicated. Yeah, see, I went up and I looked at the spelling up here. Yeah, I think it has an E on the end. So that's what I'm going with. Now down here, now under voluntary manslaughter, I don't know if is there any mitigating, or I should say mitigating. Yes, there are. Are there any mitigating circumstances through heat of passion defense? I'm not really sure. See, that's what I'm saying. I don't think there is any, but we'll bring it up here. The facts do not. There are no facts to indicate that Daniels was under a heat of passion situation. So, okay, there we go. Therefore, no voluntary manslaughter. Down here under involuntary manslaughter now. Okay. Involuntary manslaughter. Criminal gross negligence. Is when the defendant's conduct creates a significant threat or harm to human life. Here, the state may argue that Daniels not properly supplying Nan with the correct dosage and in the dispenser created a significant risk to Nan's life due to Nan's prior. Sorry, I'm coming back up here and grab this statement. Nan's previously getting confused and taking the wrong number of pills and almost dying. And then also here, okay, correct dosage of evening medication. Okay, excellent. Okay. Right here. The state may argue that Daniels not properly supplying Nan with the correct dosage in the dispenser created a significant risk to Nan's life due to Nan's prior confusion, taking the wrong number of pills, and taking the wrong number of pills. And almost dying. Okay. Thus, the court will likely find that when Daniels went on the 3-day drug binge, she created drug binge and did not supply Nan with the correct dosage of medication. Yes, Daniels was criminally, well, I was going to say this, that she created a significant risk to the life of Nan by Nan not taking the correct number of pills. Now larceny. Now we're kind of switching gears here. So now we're gonna come down here and make a therefore statement concerning the homicide murder. Therefore, the state may charge Daniels with the homicide of Nan. Okay, now down here, larceny. Larceny is the trespassory taking and carrying away the personal property of another with the intent to permanently deprive the owner thereof. Okay. Here, the facts state that, and we'll kind of come up here and grab these facts. Remember, there are no such thing as homeless facts. Right here. One day, Daniels went to work at Nan's after ingesting large quantity of narcotics. We'll use that for the intoxication offense. But Nan did not notice that Daniels was under the influence of drugs, and during the day, Daniels secretly removed jewelry from the home and sold it for drugs. Okay. Right down here. Okay, right there. Facts state that Daniels secretly removed jewelry and sold it. I'll make sure I got the facts here. Thank you for your patience. And yes, and sold it for drugs. Now we could say when Daniels came to help Nan, Daniels' action of secretly removing the jewelry would satisfy the element of taking and carrying away the jewelry being Nan's jewelry. Oh, let me spell that correctly here. Okay. All right, there we go. Nan's jewelry would satisfy the element of property of another, and the fact that Daniels sold the jewelry for drugs indicates that Daniels intended to permanently deprive Nan of her jewelry. Thus, absent a defense, the state may charge Daniels with the crime of larceny concerning the jewelry. Okay. All right. The defense of voluntary intoxication, as discussed above. Here, Daniels may argue that she was intoxicated and did not know what she was doing when she took the jewelry. However, the state necessity is exactly. Well, we could bring that up. We'll entertain that here in just a minute. However, the state will argue that. Well, here's the. That would probably be this right here. You know what? That is a great defense. We'll throw that in right here. Necessity, and we'll see why. Why it may or may not apply, and we'll let the facts be our guide on that. Now, however, the state will argue that what? That Nan did not notice what? Now let's come back up here to the facts, and again, let's look into those facts and see what they tell us about the issues. Now, that what? Daniels went to work at Nan's after ingesting a large quantity of narcotics. Nan did not notice that Daniels was under the influence of drugs. So that right here, we'll point that out down here. Right here. That Nan did not notice. She will say she needed drug money. Okay, I'll put that. I'll make a note of that down here. Okay. That Nan, okay, the state will argue that Nan did not notice that Daniels was under the influence of the drugs, the narcotics, make sure I'm saying that right, or stating the facts right. Okay, so the large quantity of narcotics. Okay. Okay, right here. However, the state will argue that Nan did not notice that Daniels was under the. Okay, the state will argue that what? That Daniels was not sufficiently intoxicated because the facts say that state that Nan did not notice that Daniels was under the influence of drugs, a large quantity of narcotics, when Daniels took the jewelry. Thus, the court or the defense of voluntary intoxication appears weak. Okay, now false pretenses. False pretenses is very similar to the elements for misrepresentation, but so we'll okay, false pretenses is the false statement of a material fact that the party knows would cause the listener to rely, or I should say the victim to rely the victim reasonably and justifiably relies to their detriment, and the victim reasonably and justifiably relies to their detriment. Okay. Here, the state will argue that when Daniels told Nan that Daniels needed money for a life-saving medical treatment, Daniels was making a false statement of material fact because Daniels knew that Nan needed Daniels' care, and Daniels took this knowledge. Well, see, Daniels used this knowledge to her unfair advantage. Was it a past debt? Oh yeah, that's right. It was actually a. Let me come up here. Let's take a look. Very good. Thank you for pointing us to the facts, because that's exactly where we needed to go. Daniels had told her she had to quit and find another job because she had to make money quickly to pay past due bills for a previous life-saving treatment. Okay, absolutely. Thank you so much for pointing that out to us. Excellent job. That needed to make money for a past due bill concerning a life-saving medical treatment. Daniels was making a false statement of material fact because, okay, yes, period. Moreover, the state argued that this statement, that this representation by was a result of Daniel's knowledge that, I want to put a scienter here. Okay, the state will argue that this false representation by Daniels was the result of Daniel's knowledge of what? Nan's need of Daniel's care. Let me come up here and grab the fact. Fear, that's exactly right. Yeah, we should point that out right here. Knowledge of Dan and fear that she might be put in a, I'm going to come up here and take a look. I think it was a, right here, nursing home. Okay. Excellent job, applicants. Very good job. Now, we need to point out the fact that Nan justifiably relied on this, though, as well. So Nan, okay. Also, the state will argue that Nan justifiably relied on this false statement when she gave Daniels the what? The $1,000. Let me come back here, but make sure I just look at the facts again. Okay, so it says on another date, Daniels told Nan that she had to quit and find another job because she had to make money quickly to pay past due bills for a previous life-saving medical treatment. Unaware that the story was not true, Nan gave Daniels $1,000. Do you check to see if all facts got used? That's a very good point. Yes, we should probably do that. So we'll come down here. Okay, had to quit and find another job because she had to make money quickly to pay past due bills for a previous life-saving medical treatment. We'll come down to make sure that was taken care of down here. That the state will argue that when Daniels told Nan that Daniels needed to make money quickly for a past due medical bill concerning a life-saving medical treatment, Daniels was making a false statement of material fact. Moreover, the state will argue that this false representation by Daniels was the result of Daniels' knowledge, scienter, of Nan's need for Daniels' care, or for Daniels' care, and fear that she might be put in a nursing home. Oh, I fear that, now it's going to say Nan might be put in a nursing home. Also, the state will argue that Nan justifiably relied on this false statement. Well, actually, they'll say this. They'll argue that Nan did not know that Daniels was. Let me down here. Let me come back up here and grab the facts that we were talking about. That was unaware that the story was not true. Okay, we'll come down here now. And the fact that no, that's different. Sorry, let me. Oh, as make sure we don't have any repeated words there. Okay. The state will argue that Nan did not know that Daniels was not telling the truth. Which caused. Well, state will argue that Nan that as a result of Nan not knowing that Daniels was not telling the truth, Nan justifiably relied on Daniels' false information when she gave Daniels the $1,000. Therefore, the state may charge Daniels, with the crime of false pretenses. Okay. Now then, the defense of necessity. Necessity is a defense when a course of conduct is necessary to avert a worse. D relied on Nan relying on the statement. Let's see. Oh, yeah. Well, actually, it's Nan relying on Daniel's statement. See here. Okay. State will argue that as a result of Nan not knowing that Daniels was then not knowing Daniels was not telling the truth. There we go. Okay, great. We'll argue that as a result of Nan's not knowing Daniels was not telling the truth. Let me go back up there and see how this was put. Okay, right here. Unaware. Unaware. That's what I want to put down there. State will argue that as a result of Nan's unawareness that Daniels was not telling the truth, Nan justifiably relied on Daniels' false information when she gave Daniels the $1,000. Okay, the necessity is the defense when a course of conduct is necessary to avert a worse result or consequence. Here, Daniels will argue that, let me point out that she needed the drug money. Withdrawal? I don't see there being a withdrawal though. That's what I'm saying. We usually talk about withdrawals for like conspiracies, possibly solicitation. Sometimes those don't even become an issue unless the facts support it. I don't see any facts supporting it. But that's a great issue though. Excellent. Oh, from the drugs? I don't see that. I don't think that she ever withdrew from the drugs. That if you could point out some, I'll come up here and take a look with you. I just see that that necessity. Okay, excellent. Okay. Oh, that's okay. Here, Daniels will argue that she needed the drug money. However, the state will counter argue that Daniels's argument is not only unreasonable, but also unsound because crime is never a viable uh, a viable action. That's because crime is never. Oh, I want to say this the right way. More okay. I counter argue that Daniels was not only unreasonable but also unsound because Daniels cannot well let me okay but also unsound. I'm gonna put a period there and support that here a little bit further. The state will argue that if Daniels I don't see I don't see that here. I just don't see that she's averting a worse consequence or result by saying that she needed the drug money. I don't see that as an argument here. However, the state will counter argue that Daniel's argument is not only unreasonable but also unsound in that Daniels cannot argue that she is averting a worse consequence by demanding or by saying she needed the drug money. Being a drug addict, I don't see that here though. That's what I'm saying, that she's not averting a worse consequence by saying she needed the money for drugs. There it is. Therefore, necessity appears ineffective. Well, it is just it's just an argument. Yeah, true. So I want to make sure we got this right. However, the state will counter-argue that Daniel's argument is not only unreasonable, but also unsound in that Daniels cannot argue she is averting a worse consequence by saying she needed the money for drugs. I think that's saying exactly what we want to say. Okay, conclusion. It uses a fact. True. True, it does. Yeah. In conclusion, the state will likely, or I should say the court, will likely find that Daniels is chargeable with homicide of Nan, the larceny of the jewelry, the false pretenses of the let's see here, $1,000, and the let me take a look. I think false pretenses. I think that's it. Okay, so we'll come down here. Yeah, it sure did go faster, didn't it? You know what? When you have the right approaches and the right attitude and the right kind of and the right I guess the mode of thought. You can get an essay like this done in very efficient time. Now, we want to make sure to talk about the defenses. How Daniels may raise the defenses of involuntary, voluntary intoxication. However, this defense may likely not work for Daniels. Okay. Any shouts? Oh, absolutely. We have a couple shout outs. Well, we have a shout out to Chess Cruncher, absolutely, through Twitch TV, Chess Cruncher TV. We got another shout out. There is a Kindle book out called the Battling the Big Bad Baby Bar. You might want to check that out. And excellent. And okay, with that, applicants, I think we could call this essay closed. And I hopefully you had a great time. And see you on the next broadcast. Hang in there and stay cool.